Hi, very good morning. This is again a Bombay High Court judgment under the Foreign Exchange Management Act. Presently, Foreign Exchange Management Act, but Bombay High Court dealt with the FERA, Foreign Exchange Regulation Act. The citation is Nega Shraf versus Union of India. So, issue before the Bombay High Court was how to determine whether a person is said to be person resident in India or person resident outside India under the FERA for seeing whether he has violated the provisions of FERA Act. So already I said earlier it was FERA, now it is FEMA. That is the only difference. But the question remains valid even today. How to determine whether a person is resident in India and to see whether he needs no permission for buying the shares in an Indian company. That was the question before the Bombay High Court. Facts: issue involved a financial transactions in which sale and purchase of shares were involved in an Indian company without prior approval of RBI. So, Enforcement Directorate investigated the matter and imposed penalties for carrying out such transactions without permission of RBI. There were many appeals before the Bombay High Court having common facts. One appeal was taken as the lead case. So, the allegation in the show cause notice was that the daughters of a person X, that person also he died. So the daughters of a person X was resident outside India and purchased the shares in an Indian company without permission from RBI, thus violating the provisions of FERA. The allegations were denied by the daughters, saying that they were not resident outside India but are residents in India only. They were only students pursuing their higher studies in USA because they showed their student visa. Their contention was that they were not there for any business or employment purposes, and hence there is no necessity to seek permission of RBI. Because I am a person resident in India, I am entitled to buy the shares of the Indian company and sell the shares also. So you cannot treat me as a person resident outside India. That was their contention. Further, their submission was there was a trust which needed funds, and hence their parents advanced temporary loans through a private limited company in which their parents were directors. So, as I already said, investigations were conducted by the Enforcement Directorate and statements were recorded. The ED and tribunal rejected the contentions of the appellants, that is the daughters, and hence further appeal was filed before the Bombay High Court. Bombay High Court considered the definitions of persons resident in India and person resident outside India in FERA. Now the definition is almost the same. There are more clauses, but the definition is still relevant. The definition considered by the Bombay High Court is still relevant. Bombay High Court said one of the crucial tests is whether the appellants had unanimous menandi. If you want to be a real good lawyer, you have to use these things. You should not say violation of principles of natural justice. You should say adi alteram partem. Then only others will respect you as a lawyer. Similarly, these terms are very, very important for a lawyer. So, unanimous menandi, that is an intention to stay for an indefinite period at one place. That has to be seen. If the person had such an intention, he could be said to reside there. FERA defines person resident in India to mean, this is very important, hence I am giving the definition. Same definition is there in the FEMA Act also, except it has got little more expanded definition and one or two words like I will tell you where they are not there. FERA defines person resident in India to mean a citizen of India who has, at any time after the 25th day of March 1947, been staying in India, but does not include a citizen of India who has gone out of or stays outside India, in either case for or on taking up employment outside, or in or for carrying on outside India a business or vocation outside India, or this is the final portion is very important, for any other purpose in such circumstances as would indicate his intention to stay outside India for an uncertain period. I repeat the last portion alone. For any other purpose in such circumstances as would indicate his intention to stay outside India for an uncertain period. So this was the portion which was looked at by the Bombay High Court. The court noted there is no dispute that the daughters were residing in USA on facts. Further, the court admitted there is no clear evidence suggesting that they were living in the USA for employment, business, or vocational purposes. That is also true. Therefore, the question that arises for consideration is whether the daughters were residing in the USA for any other purpose in circumstances that would indicate their intention to stay outside India for an uncertain period. That is the last portion of the definition. The court further noted that the late father of the daughters, in his statement, because father died and he was no more. So in his statement before the enforcement directorate, he admitted that one of the daughters was married to a chartered accountant who is practicing in USA and having his own consultancy firm in USA. In the reply to the show cause notice, there was no assertion that during the several years in which the daughter stayed in USA, the daughter returned to India with intention of staying in India. With regard to the other daughter also, the position was the same. So there is no difference. Both were married to a chartered accountant or somebody else who is there for a length of period of time. And they did not show any intention of staying in India. This is the fact relating to both the daughters. One of the contention was that by the appellants was that it is incumbent on the department to prove beyond reasonable doubt that the daughters were not residents in India, as penal provision was invoked, because heavy penalties were imposed for dealing in such a transaction. This contention was rejected by the High Court for two reasons. One, the court said it is not dealing with a criminal prosecution. Second, the court relied on section 59 of FERA, which states that the culpable mental state shall be presumed by the court. So Bombay High Court said, even though it is a rebuttable presumption, onus is on the person accused to prove it. Bombay High Court said the circumstances surrounding their stay in the USA, the length of the stay, their marriage to the persons settled in USA, lack of details about their return or any proposed return to India indicate an intention to stay outside India for an uncertain period. These are the facts. Section 71 also states that the Act prohibits persons from violating any provisions or rules under the FERA Act without permission from RBI. The burden of proving that the person had requisite permission is on that person. So that is also not proved by the appellants. Bombay High Court said that the tribunal cannot be faulted for referring to section 114 of the Evidence Act for evaluating the evidence on record. The travel records of the daughters do not rebut the circumstances. It indicates their intention to stay outside India for an uncertain period. Bombay High Court said there is documentary evidence that establishes beyond doubt the contravention of provisions of FERA. Defenses raised by the appellants were not for contravention of law, but appellants had no knowledge, being persons resident outside India. So the court held the appellants carried out the transactions of sale and purchase of shares without obtaining the prior permission of the RBI. Considering the magnitude of the transactions and the circumstances in which the same were carried out, Bombay High Court rejected the argument, saying there is no substance in the argument based on an alleged disproportionality in the penalty amounts. That was also rejected. You cannot impose a huge penalty on me. That was also rejected. The penalties imposed were sustained by Bombay High Court by dismissing the appeals. So that is a case law. Thank you very much. Have a great day.